Americans often inherit a simplified picture of the founding era. Either the United States was born a strong, unified nation, or it was merely a loose league of sovereign states. In truth, the constitutional structure the founders crafted in 1787 to 1788 is far more intricate and far more deliberate than either of those caricatures. The states did surrender part of their sovereign authority when they ratified the Constitution, but they surrendered it selectively and intentionally for the specific purpose of preventing a new, general national sovereignty. The entire architecture of enumerated powers existed to secure that limitation. Federalists promised it, anti-federalists demanded it, Madison and Jefferson later defended it. It was, at the time, the shared premise across the political spectrum. Yet this did not mean the federal government lacked sovereignty altogether. The founders created a national government that was sovereign within the particular subjects entrusted to it: war, treaties, commerce, naturalization, taxation, coinage, and the supremacy of federal law within its proper sphere. These were not trivial authorities. They were full sovereign powers, but constrained by subject matter. Meanwhile, the states retained general sovereignty over nearly every domain of ordinary life. It was a dual system, not a hierarchical one. The Union was sovereign in its limited realm, the states sovereign in their broad realm, and neither dissolved into the other. This is where many modern fringe constitutional theories lose their footing. Their historical analysis is often right. They correctly identify that the founders rejected a consolidated national supremacy, that enumerated powers are real constraints, and that the modern judiciary has inflated federal authority far beyond its intended bounds. Their mistake lies not in the history, but in the connection of its parts. They treat the constitutional system as if it were a binary opposition, federal government versus states, when in reality it is a triadic structure involving federal authority, state sovereignty, and the people bound to both. When one leg of that triad is ignored, the whole argument collapses into assertions of personal exemption or private sovereignty that just do not exist in the founding arrangement. Because they miss this deeper architecture, these theories then look outward for rescue, for a new precedent, a new ruling, a new interpretive device to prove their independence. But this impulse repeats the very flaw that broke the system in the first place, replacing constitutional meaning with judicial opinion, piling interpretation atop interpretation until eventually the structure bends under its own weight. The remedy cannot be more precedent. It cannot be a new judicial theory stacked on top of the old ones. The solution is the opposite: a return to pure constitutional interpretation grounded in the original allocation of sovereign powers. That original allocation makes an important distinction. Legislative powers are limited by enumeration. Political jurisdiction is not. A government may have narrow legislative authorities yet still possess full jurisdiction over the people within its domain. The Constitution itself, not the later judiciary, gives the United States authority to tax individuals, conscript soldiers, regulate commerce, punish offenses, enforce treaties, and bind every person in every state under the Supremacy Clause. These are sovereign acts directed toward individuals. At the same time, states retain jurisdictional authority over the vast areas the Constitution never delegated away. This is the triadic order: federal sovereignty in enumerated spheres, state sovereignty in general spheres, and the people bound by allegiance to both. Understanding this structure reveals why individuals cannot simply step outside the system their states created. In 1788, sovereignty did not reside in each person independently. It resided in the people of each state, acting as political bodies. Those bodies created the Union, delegated powers to it, and bound their populations to the resulting constitutional order. States may resist federal overreach, they may interpret the Constitution for themselves, they may push back against judicial supremacy, but individuals cannot undo a constitutional act made by their state's sovereign people. Popular sovereignty is collective, not solitary. The real path forward is therefore neither personal secession nor judicial reinvention. It is institutional restoration. A federal government returned to its enumerated limits, state governments reasserting their interpretive authority, courts deferring not to precedent as power, but to the Constitution as law, and citizens learning again how sovereignty was actually divided rather than seeking escape through doctrines that collapse when one leg of the constitutional triad is treated as optional. In this light, the limits of national sovereignty are not defects, but design, the very mechanism by which liberty survives in a large republic. The danger has never been that the federal government is too constrained or too powerful, or that the states are too liberal or too reactionary, or that the people are too easily swayed. The danger is forgetting that the Constitution was built precisely to steady those natural swings, to keep each of the three sovereign elements from overwhelming the others. Recovering that memory is not an act of rebellion, but an act of repair. It restores the Constitution to what it was meant to be, not a puzzle for judges to solve, nor a loophole for individuals to escape through, but a deliberate equilibrium of shared powers and mutual restraints. Only when all three components play their part, federal, state, and popular, does the constitutional order function as the founders designed it, balanced, durable, and free.